Recording is already part of evidence obtained by special counsel Jack Smith. Now, the former president is now facing 37 felony charges for allegedly hoarding classified documents at his home in Florida. Now, Mr. Trump pleaded not guilty earlier this month, and he has maintained he declassified all documents he took with him. But tonight, for the first time, we hear Donald Trump's voice, and he says something very different on the recording.
These are bad, sick people.
New audio obtained by ABC News features former President Donald Trump in a recorded conversation with staffers 2 years ago from his golf club in New Jersey. On the recording, Mr. Trump is heard complaining about Joint Chiefs of Staff General Mark Milley.
The courtroom atmosphere shattered the moment the judge ordered the tape to roll. Erupting in visible fury, Trump leapt to his feet, shouting over the audio to unleash a blistering tirade against the judge and the entire proceeding. Defying strict orders to sit, he surged toward the prosecution, forcing armed court officers and his security detail to physically intercept and extract the protesting former president from the federal courtroom. This unprecedented spectacle of former commander-in-chief forcibly removed while his own recorded words echoed off the walls is merely the prologue. What the public has heard so far is only a fraction of the evidence, and the very next tape the judge allowed was so devastating that it stunned even Trump's own defense team into absolute silence.
Good evening. We begin tonight with breaking news. We have obtained what is expected to be a central piece of the government's case against Donald Trump. The actual audio recording of the former president talking as if he's showing a highly classified document on U.S. war plans against Iran with people not cleared to even know it exists, let alone what's in it. In a moment, only on CNN, you will hear what jurors will hear one day. The recording was made 2 summers ago, July 2021, at the former president's club in Bedminster, New Jersey. You will clearly hear the former president as he is speaking to several people. According to the special counsel's indictment, they include a writer working on Mark Meadows' memoir, the publisher, and 2 of Trump's staff members. The president was aware he was being recorded. This is the first time it is being played publicly.
Caught on tape casually flashing highly sensitive national security secrets to a room full of uncleared guests, Donald Trump made a fatal, unforced error. In the recorded conversation, he explicitly admitted that the documents he was holding remained strictly classified, fully acknowledging that he had lost the presidential authority to declassify them. This wasn't just a moment of careless boasting, it was the ultimate legal trap snapping shut. In federal cases involving the retention of classified materials, prosecutors face the heavy burden of proving deliberate intent and knowledge. Trump's own recorded words handed the Department of Justice a golden smoking gun, effectively obliterating any future defense of naive confusion or good faith misunderstanding. Furthermore, this stark admission supercharges the obstruction allegations against him, proving beyond a doubt that he knew exactly how dangerous and restricted those files were. But the true courtroom earthquake struck during a critical procedural battle over a second set of tapes. Defense attorneys fought desperately to keep this additional audio hidden under the protective shield of attorney-client privilege. The judge, however, shattered that defense using the rare crime-fraud exception. By ruling that the communications were not seeking legitimate legal advice but were instead part of a blatant, ongoing conspiracy to conceal evidence, the court forced these secret, unreleased tapes into the light. It was the introduction of this highly damaging material, evidence so devastating that it stunned his own defense team into absolute silence. That triggered Trump's explosive courtroom meltdown and his unprecedented physical removal by armed guards. Ultimately, the audio the public has heard so far is merely the tip of a catastrophic evidentiary iceberg, hiding a much darker legal reality below the surface.
These are bad, sick people.
That was your coup, you know, against you.
Well, it started right at the
like
beginning.
when Milley's talking about, oh, you were going to try to do a coup. No, they were trying to do that before you even were sworn in.
That's right.
Trying to overthrow your election.
Well, with Milley, let me see that. I'll show you an example. He said that I wanted to attack Iran. Isn't it amazing? I have a big pile of papers. This thing just came up. Look. This was him. They presented me this. This is off the record, but they presented me this. This was him. This was the Defense Department and him. Wow. We looked at some. This was him. This wasn't done by me. This was him. All sorts of stuff. It's pages long. Look. Wait a minute. Let's see here.
Yeah.
I just found, isn't that amazing? This totally wins my case, you know. Except it is like highly confidential, secret. This is secret information. But look at this. You attack, and
Hillary would print that out all the time, you know.
she'd send
Private
it.
email.
No, she'd send it to Anthony Weiner,
Yeah.
the pervert.
Please print.
By the way, isn't that incredible? Though?
Yeah.
I was just saying because we were talking about it, and you know, he said he wanted to attack Iran and what. These are the
You did.
papers.
It's pretty
This was done by the military, given to me. I think we can probably, right?
I don't know. We'll have to see. Yeah, we'll have to try to
Declassify.
figure out a yeah.
See, as president, I could have declassified
Yeah.
it. Now I can't, you know, but this is
Yeah,
classified.
now we have a problem.
Isn't that interesting?
Yeah.
It's so cool. I mean, it's so, we here and I have, and you probably almost didn't believe me, but now you believe me.
No, I believe
It's
you.
incredible, right?
No,
Hey, bring some Cokes in, please.
The recording that just echoed through the courtroom isn't merely a piece of evidence, it is a self-inflicted legal death knell. Caught unequivocally on tape, Donald Trump explicitly brands the materials before him as highly confidential and secret, openly confessing that his presidential power to declassify them vanished the moment he left office. By brazenly flaunting these state secrets to uncleared guests, he single-handedly dismantles his own future defenses. In federal classified retention cases, prosecutors must prove deliberate intent and precise knowledge. Trump's own voice provides the ultimate smoking gun, instantly vaporizing any flimsy excuses that the files were just newspaper clippings or had somehow been declassified. When he is heard chillingly muttering, "Now we have a problem," he essentially admits to the grave illegality of hoarding the documents post-presidency. A stark realization that turbocharges the obstruction of justice charges against him. Yet, the true courtroom earthquake struck when prosecutors moved to introduce a second, tightly guarded recording. Defense attorneys fought frantically to bury this audio under the shield of attorney-client privilege. The judge, however, delivered a crushing blow by invoking the rare crime-fraud exception, ruling that these secret communications were not innocent legal strategy, but part of a calculated ongoing conspiracy to conceal evidence. It was the devastating admission of this secondary tape that ignited Trump's explosive courtroom meltdown and led to his unprecedented physical removal. Ultimately, a defendant's own voice is the hardest trap to escape. While the public has only heard the opening act of this damning audio, the unreleased, highly explosive material continues to cast a massive, inescapable shadow over the entire trial.
Let's just take a listen to how Donald Trump is trying to spin this document on Fox.
There was no document. That was a massive amount of papers and everything else talking about Iran and other things. And it may have been held up or may not, but that was not a document. I didn't have a document per se. There was nothing to declassify. These were newspaper stories, magazine stories, and articles.
So Trump wants to say it's newspapers, magazines, and articles. Obviously, we're going to wait and see what other evidence comes out as this case proceeds, Poppy.
On television, the narrative is carefully spun as a harmless, almost comical misunderstanding. A mundane pile of magazine clippings, printed memos, and everyday newspaper articles that required absolutely no declassification. Yet the private, unvarnished audio tells a wildly different and legally devastating story. In the raw recording, the speaker explicitly boasts about the secret and highly restricted nature of the documents spread before him, openly lamenting that he has lost the presidential authority to declassify them. This glaring contradiction provides prosecutors with their ultimate weapon in a federal case where establishing precise knowledge and deliberate intent is everything. When the defendant's calculated, after-the-fact public excuse collides so spectacularly with their own unfiltered, contemporaneous confession, it utterly shatters their credibility and sets the stage for a brutal, inescapable cross-examination. The underlying logic of the defense simply collapses. If these papers were merely open-source news clippings available to the general public, agonizing over lost declassification powers would be entirely absurd. Ultimately, courts and juries are routinely forced to weigh these dueling realities, and the unscripted, real-time tape almost always prevails over a polished PR strategy. While this stark discrepancy doesn't instantly close the case on its own, it severely suffocates the defense's maneuvering room, stripping away their most plausible escape routes and leaving them hopelessly trapped by the undeniable echo of their own words.
After leaving office in January of 21, President Trump illegally kept classified documents at his Mar-a-Lago social club and repeatedly tried to obstruct justice to conceal his continued retention of those documents. Highly sensitive national security information was held in a ballroom and a bathroom. As I testify before the committee today, I want to be clear. I stand by my decisions as special counsel, including the decision to bring charges against President Trump. Our investigation developed proof beyond a reasonable doubt that President Trump engaged in criminal activity. If asked whether to prosecute a former president based on the same facts today, I would do so regardless of whether that president was a Democrat or a Republican. No one should be above the law in this country, and the law required that he be held to account, so that is what I did.
Special counsel Jack Smith has deliberately and methodically cast this unprecedented prosecution not as a fleeting political skirmish, but as a defining existential test of American institutional integrity and the bedrock principle of the rule of law. By detailing the reckless stockpiling of highly sensitive national security secrets in fundamentally unsecure, heavily trafficked locations, including the glittering ballroom, a public bathroom, and various makeshift storage areas of a bustling private social club. Alongside calculated, deliberate efforts to thwart the government's recovery of those materials, the indictment lays bare a staggering breach of fundamental security protocols. Smith's central, unyielding assertion is both legally precise and historically profound. The sweeping investigation yielded absolute proof beyond a reasonable doubt, and the mandate to bring these severe charges would have remained identical regardless of the defendant's political affiliation, electoral viability, or historic stature as a former commander-in-chief. This prosecution forces a profound, unavoidable structural question upon the American Republic. It asks with stark clarity whether the stringent norms safeguarding the nation's most closely held defense information survive the chaotic transition of presidential power, and whether the justice system possesses the institutional fortitude to enforce these vital laws blind to the towering profile of the accused. At the heart of this legal earthquake is the undeniable reality that no individual, no matter how elevated their previous office, stands above the law, a foundational American tenet that is now facing its ultimate high-stakes stress test on the global stage. The physical storage locations themselves carry an independent, terrifying significance that cannot be overstated. National security protocols, forged through decades of covert operations and geopolitical maneuvering, exist precisely because the compromise of these specific categories of classified information can produce immediate and irreversible damage. The unauthorized disclosure of such documents jeopardizes clandestine human intelligence sources, unravels delicate military contingency planning, and fractures fragile diplomatic relationships that take generations to build. Placing such exquisitely sensitive material in spaces accessible to large numbers of unvetted individuals, foreign nationals, and club staff without appropriate security clearances creates a catastrophic risk profile that intelligence professionals have long treated as unacceptable. Historical reviews of earlier mishandling incidents, encompassing cases across both Republican and Democratic administrations, have consistently and unequivocally emphasized the paramount importance of strict chain of custody controls and the severe dangers of informal, cavalier retention of state secrets. What elevates this case from a severe mishandling inquiry into a uniquely devastating legal peril is the sheer permanence, clarity, and unassailable nature of the recorded evidence, which fundamentally alters the entire landscape of the trial. Unlike static paper documents or reconstructed witness testimonies that can be endlessly debated over context, chain of custody, subjective memory, or authenticity, contemporaneous audio captures the raw, unfiltered truth of a moment, freezing spontaneous admissions and exact tonal inflections in time. When a former president is caught unequivocally on tape, explicitly describing the sensitive military materials in his hands as strictly classified, openly acknowledging that he has been stripped of his presidential declassification authority, and treating the contents with the consequential gravity they demand, those spoken words transform into an inescapable legal trap. This audio evidence instantaneously vaporizes desperate defense attempts to rely on reconstructed memories, public relations spin, or post hoc rationalizations, forcing any later reiterations to contend directly with the original, unalterable words of the defendant himself. Furthermore, this undeniable proof of conscious knowledge and deliberate intent elevates the charges far beyond mere administrative mishandling into the severe felony realm of obstruction of justice. Efforts to deliberately impede a federal investigation, to hide documents from grand jury subpoenas, and to deceive federal agents transform a dispute over physical possession into a direct, calculated assault on the administration of justice itself. The courts have historically met such brazen interference with heavy consequences, recognizing that concealing records, providing materially false statements, or using unsuspecting intermediaries to erect investigative barriers strikes at the very capacity of the judicial system to function and examine evidence. When audio recordings point to active, ongoing concealment strategies, it not only fortifies the prosecution's substantive case, but also shatters the traditionally impenetrable shield of attorney-client privilege. By applying the rare and powerful crime-fraud exception, judges have exposed communications that were meant to further a criminal conspiracy rather than to seek legitimate legal advice, stripping the defense of one of its most vital protections and introducing even more devastating evidence into the public record. The radiating fallout from these staggering evidentiary revelations bleeds far beyond the wood-paneled walls of the courtroom, capturing the anxious, unblinking attention of a global audience that depends on American stability. International allies whose own national security frameworks and intelligence-sharing agreements rely heavily on the ironclad reliability of American commitments are watching these proceedings closely for any signs of institutional rupture or systemic decay. They are actively evaluating whether domestic legal standards can still adequately protect shared multinational secrets in an era of intense political polarization. Simultaneously, geopolitical adversaries eagerly scour these exact same events for evidence of internal fracture, political vulnerability, and diminished operational capacity within the United States. The public airing of a former president's cavalier, recorded discussions regarding highly sensitive military planning, even when heavily redacted or presented in partial form for trial, sends undeniable shockwaves through the global intelligence community, raising profound and lingering alarms about the long-term reliability of American classification protocols. Domestically, this profound legal crisis is continuously exacerbated by a hyper-partisan media environment that frequently distorts complex, nuanced legal questions into mere proxies for brutal electoral warfare, threatening to obscure the narrow but vital institutional stakes at play. When a defendant offers one calculated characterization in a televised public setting, framing the materials as harmless newspaper clippings and personal mementos that required no declassification, and a substantially different, highly incriminating one in a private recorded setting, the inconsistency becomes a lethal weapon for cross-examination. Prosecutors can expertly argue that the public version is merely an after-the-act attempt to reframe evidence already captured in the defendant's own voice, severely complicating any defense strategy that relies on the assertion of complete and proper declassification. Yet the physical, undeniable reality of the courtroom cuts violently through this political noise and partisan obfuscation. The unprecedented, shocking spectacle of a former president being physically extracted from a federal hearing underscores the explosive, irreconcilable tension between individual entitlement, political status, and the rigid, uncompromising demands of judicial order. Such dramatic disruptions create indelible images and narratives that permanently enter the historical record, complicating public perception and prompting intense procedural battles over contempt of court, gag orders, and the fundamental, inherent authority of a presiding judge to maintain the dignity and integrity of their courtroom against a high-profile, aggressively disruptive defendant. Ultimately, this dense, suffocating evidentiary matrix, forged from unsecure storage locations, damning contemporaneous audio recordings, shattered legal privileges, and irreconcilable public deflections, constructs an inescapable, claustrophobic labyrinth for the defense team. While the bedrock constitutional principle of due process rightfully and absolutely demands that the government bear the heavy burden to prove every single element of the crimes charged beyond a reasonable doubt, and the defense retains the absolute, unalienable right to fiercely challenge the evidence, offer alternative factual interpretations, and raise sweeping constitutional objections, the existence of a defendant's own recorded voice drastically and permanently raises the cost of those defensive maneuvers. Any legal or public relations strategy relying on sweeping, retroactive claims of absolute declassification or the trivialization of the documents must repeatedly and violently crash against the unforgiving rock of the contemporaneous audio. Juries and judges are routinely asked to weigh such conflicting accounts, but the unscripted real-time tape invariably carries the overwhelming advantage of being raw and unfiltered by later legal calculations. Long after the final gavel falls, the appeals are exhausted, and the immediate litigation fades into the annals of history, the archival permanence of these recordings will stubbornly remain. Future historians, legal scholars, and national security analysts will obsessively dissect this exact audio, these precise courtroom transcripts, and these specific legal maneuvers to understand exactly how the United States navigated the perilous, uncharted intersection of sweeping executive power, strict classification rules, and post-tenure accountability during a time of immense political fracture. The justice system's ultimate vindication relies entirely on the meticulous, impartial adjudication of the complete record by judges and juries who must carefully weigh the entirety of the facts without fear or favor. But regardless of the final formal outcome of the charges, whether it results in conviction, acquittal, or mistrial, the unvarnished, undeniable words captured on those tapes have already imposed a historic, permanent accountability of their own. They have forever altered the landscape of American justice, establishing an immutable historical record that ensures this supreme institutional test will echo loudly and clearly for generations to come, standing as a permanent testament to the enduring, albeit fragile, power of the rule of law.